Imagine the nation's top cop defending a secret deal that shields his former billionaire boss from the IRS. That was the explosive reality last Tuesday, June 2nd, when Acting Attorney General Todd Blanche faced a brutal congressional grilling. At the center of the storm is a highly controversial document Blanche signed himself, one that effectively blocks the government from touching Donald Trump's tax audits, reviews, and appeals. But here's where it gets wild. FEC records expose that Trump's PAC funneled a staggering $10 million into Blanche's law firm just before he took power. Representative Rosa DeLauro wasn't having it, cornering Blanche in a relentless, high-stakes showdown over this massive conflict of interest. Stick around until the very last second of this video, because you are about to see exactly what the administration surrendered and the shocking power they secretly kept. Here is the exchange.
Ms. DeLauro?
Thanks, Mr. Chairman. I just want to run through some questionable transactions. Mr. Secretary, President received a luxury jet from the Qatari government valued at hundreds of millions of dollars in apparent violation of the emoluments clause of the Constitution. Jared Kushner's real estate and financial deals with the Saudi royal family raised serious questions related to kickbacks and bribery that could be in violation of federal bribery laws and the Foreign Corrupt Practices Act. White House advisor Peter Navarro, a friend of Donald Trump Jr., got the Pentagon to loan more than $600 million to Vulcan Elements, a small North Carolina startup founded just 2 years earlier. And Donald Trump Jr.'s venture capital firm has a stake in this company. Estimates of the company's valuation grew tenfold after the deal was announced. AAFS Infrastructure and Energy, which is on the cusp of securing a waiver, a $1 billion contract to build and operate a pipeline across the Balkans, has ties to former National Security Advisor Michael Flynn and a lawyer, Jesse Banal, that defended the president and Donald Trump Jr. against a lawsuit that sought to hold them responsible for January 6th. This company would be allowed to ship fossil gas from the United States to replace Russian fuels. My question is, and we know that the administration, you gutted the public integrity section for the last 50 years, investigated, prosecuted crime related to government integrity, and they prosecuted both Democrats and Republicans. Simple yes or no question. What I've just mentioned, do you believe that what I've talked about is enough here for the next Attorney General to open a criminal investigation? Yes or no?
No, you just read a bunch of random, unsourced news articles and reports. No, that's not the basis to open a criminal investigation. I mean, you're looking around, but it's not.
This is not the basis on which
it is not. Just reading something that's just a hypothetical off a news article, it's not.
It's not a hypothetical. It is real. Did the president get a Qatari? What? Do you read the press? Are you knowledgeable?
Not the same press you do.
Apparently not, my friend.
Promise.
Apparently not. Did the president receive a luxury jet from the Qatari government valued at hundreds of millions of dollars, which is a violation of the emoluments clause of the Constitution?
It is not. It is not.
Wow, you do not belong in this job, Mr. Acting Attorney General. You should always recuse yourself from these issues because you are the president's lawyer. You are not the lawyer for the United States. Yes, you are.
I am not.
Thank you, Mr. Chair.
Mr. Clyde.
Okay, so within hours of last Tuesday's testimony, the administration was framing the scrapped fund as some kind of meaningful concession. And in narrow terms, it was $1.776 billion in taxpayer money controlled by a commission he himself would appoint, with no mandatory public disclosure and no path to appeal. DOJ says that program is not going forward. We are not moving forward with the fund, period, he told Congress. But here's what I need you to understand. The audit bar addendum, the one covering his former client's pre-settlement tax returns and barring related claims and relief, remains in place. Blanche confirmed during his congressional testimony it would stay regardless of the fund's cancellation. The fund was the piece they announced publicly. The audit bar addendum is the piece that survives. And just to drive home how extraordinary this is, two former IRS commissioners who ran the agency under different presidents have gone on the record about this. John Koskinen oversaw the agency across the Obama and first Trump years. He told PBS NewsHour he'd never once been aware of the IRS promising a taxpayer, as part of any settlement, that it simply wouldn't audit them going forward. Never. Daniel Werfel led the agency until January 2025. He called it an unprecedented remedy and said Americans expect the same enforcement framework to apply to everybody. Two men who ran this agency, both saying the same thing. They have never encountered anything like this. Now, to understand why this is such a big deal, you have to understand what it's actually dismantling. The mandatory presidential audit policy has existed since 1977. Here's why it exists. During the Nixon administration, a congressional investigation found he'd been filing erroneous tax returns. The Joint Committee on Taxation determined he owed additional taxes, and because of that, the IRS put a formal rule in place. Presidential returns get audited automatically every single year. No individual employee decides whether to proceed. That's the whole point. Nobody at that agency should ever face political pressure about whether to scrutinize the most powerful person in the country. That protection, gone. The acting attorney general signed it away on May 19th, one day after the settlement's effective date, with an addendum barring covered claims, examinations, and all related relief, including returns filed before that date. And here's where it gets really specific, because this isn't abstract. This audit had been publicly reported on for years. Joint investigations by ProPublica and the New York Times identified a long-running IRS inquiry into a technique the president reportedly used on a Chicago real estate investment. The issues were so novel, the IRS commissioned a high-level internal legal review before it would even pursue the claim. Tax experts working with those newsrooms estimated that if the IRS prevailed, the resulting bill could exceed $100 million, interest and penalties included. Was that audit still open on May 18th? Not public information. If it was active and within the settlement scope, the agreement bars its pursuit entirely, without any court ever weighing either side's arguments. Think about what that means. Now let's talk about who signed this, because the conflict of interest here is extraordinary. An ABC News review of FEC records found the president's Save America PIAC began paying his law firm in the spring of 2023, right as his client was preparing for arraignment in Manhattan during the hush money trial. The PIAC was paying his firm upwards of $800,000 a single month. Every day of those proceedings, he publicly defended his client to the press. The Senate confirmed him as Deputy Attorney General in March 2025, 52 to 46. He was elevated to acting Attorney General in April of this year, when the previous Attorney General was dismissed, and also in May, he signed the audit bar addendum. That's the chain. Take that in. There's a law you need to know about because most people don't. Section 7217 of the U.S. Tax Code. It makes it unlawful for the president, or anyone in the executive office of the president, to directly or indirectly tell the IRS to start or stop an audit on any specific taxpayer. Violating it? Up to 5 years in prison. The Attorney General holds a narrow carve-out, but the White House does not. The NYU Tax Law Center says if White House officials participated in or reviewed the settlement's terms before that addendum was signed, their involvement could raise serious risk of a statutory violation. The administration hasn't disclosed whether any White House staff were involved in those negotiations, so we don't know, and they're not telling us. Now, here's something that should have gotten way more coverage because the timing here is not a coincidence. His legal team filed a voluntary dismissal on May 18th, the same day the fund was publicly announced. And according to Reason and Roll Call, that was days before a court deadline. U.S. District Judge Kathleen Williams had required both sides to brief the court on whether this lawsuit even met the constitutional requirements for federal court review. Let me say that again. A judge had already ordered them to explain whether this case should exist at all. They filed the dismissal before that deadline hit under a procedural rule that means when a defendant hasn't answered yet, you can walk away without judicial approval. In other words, they got out before a judge could ask the question. Now, federal courts in 2 separate states are actively reviewing challenges to this deal. 35 former federal judges filed a motion in the Florida case charging the settlement was a product of collusion and a fraud on the court. Williams, who had originally closed the Miami case after receiving only the dismissal notice without the full settlement terms, cited those allegations and reopened it. She ordered his lawyers to respond by June 12th. In Virginia, U.S. District Judge Leonie Brinkema issued a temporary restraining order on May 29th and halted all fund operations before any funds were transferred. And here's why that matters. Under Federal Rule of Civil Procedure 60 subsection D, if a court finds fraud on the court, it can set aside a judgment. Doesn't matter when it was entered, it gets voided. Let me explain where the money was going to come from because this part is constitutionally significant. It wasn't coming from a new congressional appropriation. The Attorney General's order directed the Treasury Department to transfer $1.776 billion from something called the Judgment Fund. Here's what that is. It's a permanent account Congress set up to pay judicial and administrative awards against the government and to cover DOJ settlements in actual or imminent litigation. That's what it's for. DOJ later confirmed in court filings the fund hadn't been set up and wasn't going forward. Republican Congressman Brian Fitzpatrick of Pennsylvania told NPR, and I want you to hear this, the executive branch holds no money of its own. Every dollar flows from an appropriation Congress has authorized. The NYU Tax Law Center called this an unprecedented use of the Judgment Fund. And the cases the administration cited as precedent, unclaimed funds distributed to class action claimants. Completely different from a personal lawsuit filed by a sitting president against agencies under his own authority. And the political fallout? It crossed party lines, which almost never happens anymore. Republican Senator Susan Collins chairs the Senate Appropriations Committee and faces voters this fall. She said she did not support the fund. She did not believe individuals convicted of violence against police officers on January 6th, 2021, should be entitled to reimbursement of their legal fees. And she didn't just say it, she voted it. When Democrats moved to kill the fund outright during the immigration bill's overnight vote, she voted for the amendment alongside 2 other Republicans. Fitzpatrick called the arrangement wrong on multiple fronts, morally and legally. The opposition stalled the GOP's own immigration enforcement package. Senators couldn't pass it before the Memorial Day recess. When they came back, Senate Majority Leader John Thune declared the fund a settled issue, cited the acting Attorney General's testimony, and moved the vote. The Senate passed the $70 billion package, 52-47. Not a single line in it banning the fund. Here's what he said when Congress asked him to put it in writing. Democratic Representative Grace Mung asked him directly, would he commit in writing to a formal memo rescinding the May 18th announcement? His answer, as reported by Reuters, I'm not committing to doing anything in writing. She said she was concerned because he was not under oath. 3 days later, DOJ attorneys filed court papers arguing the fund has not been set up and is now not going forward. So the written commitment he refused to make during last Tuesday's testimony showed up Friday, June 5th, in a legal brief where DOJ told 2 courts the lawsuits were not justiciable. And the president publicly stated midweek he wasn't sure the fund was even dead and still believed January 6th defendants should be compensated. Through all of it, the audit bar agreement remains in place, signed and in effect. Now, here's what most people missed. This was not the first time. In April, the House Judiciary Committee ranking member, Jamie Raskin, launched a formal investigation into the administration's reported payout of $1.25 million to Michael Flynn, the president's former national security advisor. The committee's press release described the payment as drawn from the same taxpayer-funded judgment fund. In his letter to the acting attorney general, Raskin called it a warning sign, writing that it offers a roadmap for this epically corrupt president to keep paying out his political underlings and private militiamen with taxpayer money. Flynn had pleaded guilty to lying to the FBI. A federal judge, U.S. District Judge Mary Scriven in Florida, had already dismissed his malicious prosecution lawsuit in December 2024, ruled it failed to meet legal standards, and warned him any refiled complaint better not cross into frivolous territory. Lawfare obtained the full settlement agreement through a FOIA lawsuit and confirmed it. The administration paid him $1.25 million from taxpayer funds anyway. So, consider all of it. Here's what the full arc adds up to, because this is what corruption actually is. The acting attorney general spent 2 years as the personal defense attorney for the man who now runs the executive branch. He took a job at the Justice Department under that same man's appointment. He used that office to execute a settlement, signed under his own name, that bars the U.S. from pursuing claims tied to his former client's tax returns. Brandon DeBott, policy director at the NYU Tax Law Center, put it this way: "This is the president trying to play every role in the system, acting as plaintiff, defendant, and his own judge and jury to extract extraordinary windfalls." And when this settlement first became public, Harvard professor of government Ryan Enos wrote, "I say without hyperbole that this is the most brazenly corrupt action in U.S. presidential history." Here's where things stand. The addendum is part of a legal settlement that can only be modified through the written agreement of both parties. The Florida inquiry stays open. His lawyers must respond to the fraud on the court allegations by June 12th. The acting attorney general confirmed the agreement would remain in place. It applies to the president, his sons, the organization, covered related matters, all of it. Whether the Chicago audit exposure was still active when this was signed, not public. If it was, the addendum purports to bar it. That exchange took place last week, and the person who made all of this possible spent the 2 years before his appointment billing the president's political fund by the month. Before I go, tell me what stood out to you the most. Share your answer in the comments below. Leave a like if you want to support what I'm doing here. Hit the bell so my next upload doesn't pass you by. Subscribe to the channel if you haven't already. Thank you for watching, and I'll catch you next time.